conclude our series of engagements on reform of the family law system. And I want to welcome all our guests here this morning from Men's Voices Ireland. We are joined by Mr. David Walsh, who's the chairperson, and Mr. Frank McGlynn. We are also, and they are accompanied by Mr. David Drakeford, spokesperson for NEMO Forum. We're joined by the Special Rapporteur on Child Protection. You're very welcome back before us, Dr. Geoffrey Shannon. And from FLAC, we are joined by Ms. Eilis Barry, the Chief Executive, and Ms. Stephanie Lord, who is the Legal and Policy Advisor. And from UCC, and not for any other reason than logistics, we're joined by Dr. Kenneth Burns, Senior Lecturer in Social Work, who is sitting out there a little bit on his own. And it's for no other reason than accommodation. You are all very welcome, and I shall shortly invite you all to make your opening statements, and I propose to proceed in the order in which I've introduced you. Firstly, I must draw the attention of a witness to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given. And you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person or persons or entity by name or in such a way as to make him or her or it identifiable. And members of the committee should be aware that under the salient rulings of the chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. Now, before inviting Mr. Walsh of Men's Voices Ireland to make the opening statement, Mr. McGlynn, I beg your pardon. I was taking it in the seating order, and there we are. I'm corrected. But before I invite Frank to make the first opening statement, I just want to ask you all to please make sure that your mobile phones are on silent, because they interfere with the recording equipment here in the committee rooms. And if our visitors in the visitors gallery would accede to the same request, please. So I'd now like to invite Mr. McGlynn of Men's Voices Ireland to make his opening statement. Thank you.
Thank you very much, Chairman. We appreciate the committee's invitation to Men's Voices Ireland and the NEMO Forum to address you on family law. Because the family law system has evolved over the past 40 years with very little regard for the rights, needs, interests and experiences of men. We find that the family courts are adversarial, they exacerbate hostility, they create ill will, and they're bad for parents and children. The system is overloaded, delays are frequent, and we understand that judges dislike family law cases. Instead of addressing a social issue, family law has evolved into a high-growth civil law industry, which thrives on exploiting conflict, and it benefits only lawyers and solicitors and other professionals. It plunders scarce family resources, which are even more stretched following a separation. The system takes far too long to reach a settlement. Legal fees are very expensive and place lay litigants at a disadvantage. Men are less likely to qualify for legal aid, and very many are unable to afford legal representation. A point made repeatedly at the hearing here on the 6th of March was that the threshold for legal aid was too low and disadvantages men. Children suffer from costly, long drawn-out conflict and are also used as pawns in custody battle. Joint custody in a real 50-50 sense occurs in only about 1% of cases. We believe that breaches of access orders should be dealt with firmly, with sanctions imposed. Currently, this does not happen. Outcomes in family courts are bad for men, and this is well attested. Too often, it's a winner-takes-all situation in which the man is removed from the home. He may still have to pay maintenance and a mortgage, as well as provide for himself. Furthermore, he will often discover that access to his children is gravely diminished, in many cases because he can no longer provide suitable accommodation for himself and his children due to his removal from the family home under Section 10 of the Family Law Act 1995. There is a need to reform the law and remove Section 10 of the 1995 Act to prevent these disastrous outcomes. This is also essential to ensure that mediation is entered into meaningfully by both parties. Alternative dispute resolution produces far better, more conciliatory results in a shorter time and costs a lot less. There's evidence for this from the Irish mediation services, as well as from Finland and New Zealand and elsewhere. It has much better outcomes for children. It should therefore be regarded as normal procedure. Application to the courts should only be made in the event of failure of mediation, and it should be regarded as the exception, not the rule. As you will see from the support and documentation which we have supplied, many of our proposals, such as the introduction of families in transition programmes, the replacement of the civil bill with proposals for the reorganisation of the family unit, and mandatory mediation, are designed to reduce hostility and expectations of victory, which are inherent features of the current family law system. We would hope that these proposals would be of interest to and given due consideration by the committee. I'll now hand over to my colleague David.
Thank you. We strongly support the case made by Troer for automatic guardianship rights for both parents, for unmarried fathers, and the need for a central register for these documents. In the tussle between competing parental rights, the rights of the child are being lost. We emphasise instead the principle of equal rights for both parents. Current practice puts the adult at centre stage, whereas the child's welfare should be paramount and the child's fundamental right to know and to spend time with both parents. Reference was made at the hearing on March the 6th to a case where a father was alleged to have been violent and was denied access as a result. Apart from the fact that such an allegation does not need to be proved beyond reasonable doubt in a civil court, a father still retains his right to be a father to his child, as one judge affirmed in Dolphin House recently. But this is not common practice, and once again underlines the need for clear parenting guidelines and for compliance with these. We also strongly support the case made for mediation where domestic violence is alleged, and not just for the reason above. The term domestic violence covers a very wide range of behaviour, from physical violence to abusive behaviour such as emotional and psychological abuse. We know from a wealth of sources that around 50% of domestic violence is mutual, it's reciprocal, it's engaged in by both parties. In such situations, there is not an identifiable, mutually exclusive pair of victim and perpetrator. This crucial point is not recognised at all. There are many surprising findings about domestic violence which are relevant and which are not known, but which are listed in the sources cited in our written support. We would be happy to expand on that if required. Parental alienation is now recognised as a serious problem by a number of commentators. In a Dáil debate in February 2015, two deputies referred in graphic terms to parental alienation. I quote from one of these: "There is an enormous problem where people are estranged of the primary custodial parent, who most often is the mother, deliberately obstructing fathers from accessing children. They are using children as pawns, going to war with fathers, causing some fathers to have nervous breakdowns, and destroying relationships deliberately between children and fathers." Hearing the voice of the child does sound attractive, but it does need to be approached with great caution. As one expert has said, it is a question of differentiating between the expressed wishes of the child and the ascertainable wishes and feelings of the child, and this requires expert professional advice. This issue is covered in much greater detail in the written submission by NEMO Forum. Finally, I want to refer to fatherlessness or father absence. It's a huge problem whose importance has not been sufficiently recognised. There is ample evidence that children, especially boys in this situation, suffer a range of behavioural problems. The US academic Sarah McGlynn found negative effects of father absence on outcomes in educational attainment, in mental health, in relationship formation and stability, and in success later in the labour force. Boys who grow up without a father are twice as likely to end up in jail as those from two-parent families. She found strong evidence that father absence negatively affects children's social emotional development, and these effects are more pronounced in boys than in girls. The US academic Warren Farrell gave this warning in 2015. He said, "Prisons are centres for dad-deprived boys." This shocking statement underlines the importance of fatherhood and how we neglect it at our peril. The issue of father absence needs to be moved far higher up the agenda than where it currently lies. We thank the committee for their attention and stand ready to take questions.
Thank you very much indeed, Frank and David. And my understanding is that, sorry, bear with me just for one moment. Just looking at the ordering of this, I understand that David is joining you in the Q&A in terms of responses to members at the question time. Thank you for that. So I'd now like to invite Dr. Geoffrey Shannon to make his opening statement. Dr. Shannon.
I would like to take this opportunity to thank the committee for the invitation to address it on the topic of reform of the family law system. My opening statement will focus on three of the issues suggested for discussion. These are the structure of the court system, alternative dispute resolution, ascertaining the views of the child during family law proceedings. Ireland does not yet have a specialised family or children's court system. Such systems are commonplace across Europe and in common law jurisdictions. The establishment of a specialised family and children's court system is a recommendation in the Council of Europe guidelines. The intention to establish such a system has been announced, but the necessary detail, resources and implementation are now needed in order to make those plans a reality. In the 1980s, the probation service sat in every family law case, but that changed in the late 1980s as the probation service concentrated on criminal law cases. This left a significant gap which has never been filled. It should be acknowledged that the President of the District Court, Judge Rosemary Horgan, has introduced innovations in the Dublin Metropolitan District Court. Admirably, the Chief Justice, in his first public address, focused on access to justice. That said, much broader structural reform is needed to ensure our family law system meets the needs of citizens who access the system at a vulnerable time in their lives. The proposal set out by the Law Reform Commission Family Courts Working Group in 1996 recommended the establishment of a two-tier court system, the District Court and the Regional Family Court. Under this proposal, the lower tier would have some of the jurisdiction the District Court currently has, but that court would not make final orders. The second tier proposed was the establishment of regional family courts with information centres attached. These were to be the same tier of jurisdiction as the current Circuit Court and would use specifically trained members of the judiciary. The second tier, to be known as the Regional Family Court, would have jurisdiction on all issues. An analysis of the family law court system in England and Wales and Australia suggests a model which is not overly interwoven with the rest of the court system. Managing the type of case which goes before each tier of the court also emerges as a key issue of importance. In England and Wales, they operate a very strictly run gatekeeping system of ensuring the cases are allocated to the most appropriate tier within the system. The mechanism of managing which case goes to which court is best suited to the Irish context. Cuts to legal aid budgets have led to proceedings which are more drawn out and more difficult to resolve, where adequate support is lacking. The time constraints faced by professionals actually cost more money in the long run, and that's something we sometimes forget. Penny-wise, pound foolish, and I think that's something we shouldn't lose sight of. It has often been emphasised that the common law adversarial system is highly unsuited for family law cases, as parents are focused on winning and their disputes can be psychologically damaging for both them and their children. It is unclear whether inquisitorial systems are better for family law and for proceedings concerning children in particular. Alternative dispute resolution has been recommended as an area for greater attention, having regard to international practice and what will be possible in Ireland. Mediation and other alternative dispute resolution approaches appear to result in more amicable and enduring arrangements, with the attention of parents more likely to be on the children's needs. There are issues relating to power dynamics in relationships, and children are often excluded from alternative dispute resolution. Therefore, it should be seen as a useful alternative mechanism for resolving family disputes, not as a cost-saving measure. A family law system must be equipped to not only have children present, but also to facilitate them to have meaningful involvement in proceedings. Courts in Ireland have a duty to hear children and to give due aid to their wishes. Article 42A of the Constitution provides a more heavily entrenched right for children to be listened to in private family law cases. There is a distinct lack of provision in Ireland for hearing children. Guardians ad litem are often the most effective mechanism in which children can present their views to the courts, yet they may or may not be appointed in a given case. I've made a number of recommendations in the submission to the committee. I'd like to focus on 3 or 4 of those by way of conclusion. Any new family court structure must recognise and actively promote an interdisciplinary system to ensure effective communication between all disciplines involved in family law. In private family law matters, key services should be available to permit family law judges to refer couples or parties to skilled personnel to draw up parenting plans, carry out parenting capacity assessments, deal with anger management programmes in domestic violence cases, monitor custody and access orders when they break down and facilitate their restoration, engage in family therapy, implement supervised access orders. The key ancillary services are an essential part of any new family court system, and if there is any message I'd like to communicate this morning, it is the importance of those key ancillary services. Without these services, any new system remains as flawed as the current one. Other practical matters that are necessary to ensure that child and family law matters proceed smoothly include having translators within easy reach to avoid lengthy delays or adjournments when there are language problems. Judges must set firm timetables for cases. Timetabling and case management decisions must be child-focused and made with explicit reference to the child's needs and timescales. This recommendation should be underpinned by primary legislation, as delay and drift have a profound impact on the welfare of children and families. The message from other jurisdictions is unequivocal, and that is that children and family services in the court are best managed by a dedicated and integrated family court structure that is properly resourced to meet the particular needs of people at a vulnerable time in their lives. Ireland must now invest the resources to ensure that its court system is fit for purpose. It should be not only meeting the requirements of the UN Convention on the Rights of the Child, the Council of Europe guidelines and other international standards, but it should be leading the global inclination in favour of specialised family law systems and of involving children in proceedings affecting them. I would like to thank you very much for taking the time to listen to me, and I'll be happy to answer any questions that you might have.
Thank you very much, Dr. Shannon. And we now move on to Ms. Eilis Barry, who will make the opening statement on behalf of FLAC.
Thank you. FLAC welcomes this opportunity to make a submission to this Oireachtas committee and welcomes the focus of this committee on this very important issue. Family law is the largest area of queries on our information phone line and in our legal advice clinics, which operate in 67 locations around the country, where volunteer lawyers provide legal advice. Also, as part of our public interest law project, McCann Fitzgerald Solicitors has partnered with Women's Aid and provides advocacy for women who are representing themselves in family law matters. For 50 years, we have been promoting access to justice, which obviously includes access to legal aid, but it also importantly includes access to the courts and effective remedies. What happens in the court is vital to access to justice. Access to justice is about democracy, as provisions in legislation which this Oireachtas has enacted are such as the very important provisions in the new Domestic Violence Act, which we welcomed. Those provisions will only be as effective as if they can be enforced. Access to justice is also fundamental to the rule of law, as it enables state bodies who are involved in family law, like TUSLA and the HSE, to be held to account. But fundamentally, it's about social inclusion. People who present at FLAC clinics or in our casework often have a number of legal issues going on at the one time. And it's very important not to view family law and the family courts in isolation. Family law problems very often are accompanied by debt, unemployment and housing problems, and homelessness makes all of these issues so much worse. Solving an issue like housing or homelessness may have a positive impact on family law matters, such as enabling access or custody to actually take place. And addressing these issues together will increase social inclusion. The Legal Aid Board and the court services are public bodies and statutory bodies, and the positive duty which is set out in section 42 of the Irish Human Rights and Equality Act 2014 imposes an obligation both of the Legal Aid Board and the court services to promote equality and human rights. And what we mean in this context is the human rights of access to legal aid, and also complying with the provisions in the Equal Status Act, which require the court services to be accessible and to ensure that there's no discrimination on any of the grounds that come within that legislation. And it also requires the reasonable accommodation of people with disabilities. As you know, legal aid and advice, the state system is administered by the Legal Aid Board. We believe that the Legal Aid Board and the court services need to be regarded and treated as fundamental to the administration of justice and the rule of law, and to be resourced appropriately. And the court services were hit very badly during the recession in terms of their budget, and that needs to be addressed. We welcome the committee focus on this issue, but we would invite the committee to cast their forensic eye, in particular on the issue of legal aid. Problems with the provision of legal aid include problems with delays, means test, the contributions, the waiver, the issuing of certificates, and the areas of law excluded. And also, we would submit that there's a lack of transparency around the reasons of refusal for legal aid and the amount of financial contributions that's actually collected. It's very important, and I want to emphasise this, to pay tribute to the work of the staff of the Legal Aid Board, who are facing huge demands on their services. Nothing that we say here should be seen as a critique of their work. It is somewhat like the health services. The services from the staff is excellent, but the problems arise from the structures and resources. In terms of delays, there's a waiting time in law centres of 10 months and over for a first consultation in the Blanchardstown and Finglas Law Centre, 33 weeks in the Cork Law Centre, and 32 weeks in Tralee. The means test hasn't been amended since 2008, and we understand that the department is open to reviewing the means test, and that the Legal Aid Board have submitted recommendations for review in this regard. To qualify for legal aid, a person must have a disposable income of less than 18,000 a year, as well as a disposable capital of less than 100,000. Now, the family home isn't considered as means when assessing capital. There's also allowances which haven't been reviewed since 2008, and one of the allowances includes 8,000 per year for accommodation costs. Now, given that the accommodation costs per month, it's far below what you would pay for private rented accommodation or a mortgage property. There's also an allowance for childcare expenses of up to €6,000 per annum, whereas the average childcare costs amount to €1,000 per month. We would argue that the means test needs to be poverty-proofed and reviewed on an ongoing basis. We also argue that the Legal Aid Board should have a discretion to provide legal aid in certain circumstances where people have failed the means test. We have seen a case where a hospital or was intending to make an application to a High Court in respect of the medical care of a seriously ill, terminally ill child, and the parents failed to meet the means test. They had no money because they had been out of work for a number of months taking care of the child. They failed to get legal aid in that instance, and I think in cases of exceptional importance where people fail the means test, the Legal Aid Board should have a residual discretion. In relation to financial contributions, you would think that someone on an income of 18,000 or less would not have to make a financial contribution towards legal aid. And unlike the medical card, legal aid is not free. The minimum contribution for legal aid is €130, which may not sound like a lot, but it's very significant if you're on social welfare, and if you're on it exceeds the reduced rate of social welfare that is paid to someone under 26. We have heard of figures of contributions in their thousands been made by people who are in receipt of legal aid if the legal aid relates to the sale of the family home. There is a waiver, there is a possibility of getting a waiver if the contribution might cause hardship, but we believe that that waiver provision isn't well known and it isn't advertised. We campaigned to have the financial contribution removed for victims of domestic violence, and we were successful in that campaign. But a person still has to make a financial contribution when they go back to the courts in relation to access, custody or maintenance. In relation to the issuing of legal certs, there appears to be an unofficial rule in operation that a person will only get the maximum of 2 certs per year. This doesn't make sense on any level. Apart from the impact on the parties and bringing the families having to make repeated trips to the court over extended periods of time, it would appear to be a far better use of court time and legal aid staff to have all applications dealt with from the outset. In relation to exclusions then, there is a lack of clarity as to whether there is legal aid available in housing cases, which is very closely related to issues that arise in family law cases. In this regard, FLAC submitted an amendment to the Department of Justice, which, if enacted, would ensure that legal aid was available to anyone facing eviction from the family home. This would include people in long-term mortgage arrears or people facing evictions from local authority housing. We need more transparency from the Legal Aid Board in relation to the use of the waiver, the level of contributions that are collected, and the number of refusals of applications for legal aid and the reasons that accompany those refusals. Stephanie will now deal briefly with the issue of access to the courts.
Thanks, Eilis. I'll be very brief in my comments. Before I begin, I just want to reiterate our thanks to the committee for inviting FLAC in to present on this very important issue. As Eilis has pointed out already, access to justice is fundamental in that it allows people to access their other rights, but it also enables people to hold other state agencies to account, such as TUSLA and the HSE. And I want to take a few minutes to focus on some of the more practical aspects of access in the Irish courts that should be addressed if there's to be meaningful reform of the family law system. Given the limited nature of legal aid and the restrictions on what you can be granted civil legal aid for, many people end up representing themselves in the courts. This raises all sorts of difficulties for individuals because of how complex the processes are. We've made a lengthy submission to the committee in which we've made a range of recommendations regarding accessible forms that could be made available to people that would assist in making it easier for people to represent themselves in the courts process. We've also made a number of recommendations around examining the provision of unbundled legal services and further statistics that could be compiled so that we might eventually gain a better picture of the true needs of family court users. We've also made a range of recommendations to address the difficulties that are faced by people with disabilities in the courts, such as inaccessible courts, inaccessible offices of legal practitioners, legal documentation being unavailable in accessible formats, and the procedural systems being too complex to navigate. They absolutely need accessible formats and accessibility testing because, quite obviously, people with disabilities are involved in family law proceedings in our courts. We've also made a number of recommendations regarding the availability of information for people who speak Irish Sign Language. And we do recognise that the court service have made some improvements in terms of accessibility, in particular for people who use hearing aids, but there's a lot more that could be done. There are very clear problems with the actual physical infrastructure of the family courts in Ireland. Hearings on domestic violence, guardianship, children, maintenance and matters pertaining to passport applications and blood tests are heard in Dolphin House in Dublin. And Dolphin House is the family court area. It deals with family court issues in the Dublin Metropolitan District, except for swords. But despite the large geographic area that Dolphin House caters to, it's not, the court building itself isn't equipped for the high volume of people that are actually using it. Just a point on the speakers of other languages, and this is an issue across all of the family courts, not just in Dolphin House, but the lack of regulation and legal interpretation services is a major issue. FLAC would have concerns about the quality and the availability of interpretation that has currently been provided. And given that there can often be very, very significant and important constitutional rights in the balance in these cases, this is an issue of major importance. People who don't have sufficient English language skills are just as entitled to access justice as anybody else in the courts process. But we do absolutely recognise the work of the court service staff and legal practitioners within the court. However, it is at full capacity at the moment. I just want to take a moment to talk about Dolphin House in particular. My work is research-based, and generally I don't visit the courts, but I did visit Dolphin House recently. And I found the building to be, the entire experience to be rather shocking. It was filled with people, many of whom are in a very vulnerable position, a lot of people from very marginalised communities, and it's common practice for people to have to engage in consultations with their solicitors in the hallways and on the stairs because there's so few consultation rooms that are available, and the ones that are there will already have been occupied. Women a lot of the time have children with them because of childcare issues, and it's very unclear when you enter the court itself or the court building where you have to go. There's a set of stairs in front of you and you see people carrying buggies and prams up and then they have to return back downstairs. People are having consultations with their solicitors in full earshot of complete strangers where they discuss issues, very intimate details of their lives, having to discuss issues around their mental health and their physical health, where it's completely audible to the people standing beside them. There are visibly distressed people in the courts and upset children, and they're cramped into what is quite a dirty and poorly laid out building. Because of the lack of space in the family law courts, applicants and respondents generally have to wait in the same area, and this can be particularly distressing for victims of domestic violence. It makes it especially difficult when you see women who are having to have consultations with their solicitors and the respondent is in the same area. A further issue is that when a person's legal aid certificates have run out, they're very much dependent then on the court service staff to explain the basic information to them on the different orders and the processes that are involved and the requirements needed to apply for them. And the court service do their best, but it isn't inappropriate. That's not a replacement for proper legal representation and access to proper civil legal aid. And while I'm speaking about Dolphin House in particular today, we understand that the lack of consultation space is something that comes up in courts across the state. Were the courts and legal aid to be resourced appropriately, it's our view that this would reduce massively the legal costs in the long term because cases would be proceeded with appropriately. Civil legal aid is consistently viewed as the poor relation of the welfare state, and we'd very much like to see this examined and changed. And FLAC would be happy to attend this committee again and to meet any of the individual members if they wish to discuss this issue further. Thanks.
Thank you very much, Eilis and Stephanie. And now to Dr. Kenneth Burns from UCC. And thank you very much indeed, Dr. Burns.
So thank you for the invitation to address the committee today. I plan to focus on 3 issues. The first, the impact of the in-camera rule on hearing from children and families. B, the need for consistency between courts, and C, articulating a clear model for childcare proceedings. My knowledge of these issues is based as being a principal investigator of 2 research projects, one on childcare proceedings in the District Court and the other on voluntary care arrangements, as co-editor of a book examining child welfare removals in 8 countries, an educator, and also as a former frontline practitioner in child protection and welfare. I endorse previous comments made to the committee by Dr. Romani from UCC and Dr. Carol Coulter and Maria Corbett from the Childcare Law Reporting Project. So therefore I'm intentionally not addressing themes that I feel are important but were previously addressed by them. Updating the in-camera rule, the voice of parents, children and young people. Through our research and discussions with experienced judges and legal practitioners, it has become clear that the in-camera rule is poorly defined in Irish law, despite recent clarifying amendments in 2007 and 2013. The precise parameters of what is permitted are not set out, and whether any particular conversations about a set of in-camera proceedings would breach the rule largely comes down to the subjective opinion of individual judges. These amendments focus largely on permissions for attendance in and the reporting of these proceedings, and do not appear to cover research with participants outside of the proceedings. In essence, any person who was involved in an in-camera proceeding, whether in the field of child protection, private family law, or otherwise, risks being held in contempt of court every time they discuss the proceedings with anyone other than their legal representative or other parties in the proceedings. The law neither clearly allows nor permits interviews with children, young people and their parents. In the absence of clarity, researchers, children, young people and parents are at risk of being held in contempt. This is not just a matter of academic concern. We should be proud of recent developments in Irish legal, constitutional and practice reforms, which have sought to promote the participation of children, young people and parents, to ascertain their views and to facilitate greater involvement in decision-making. We now have a considerable amount of quality Irish research on the operation of childcare proceedings. However, the specific issue I have documented with the in-camera rule has had a chilling effect on research, thereby silencing the voices of children, young people and parents who are most impacted by these proceedings. Further to observations previously made at this committee, this is further evidence that there is a significant implementation gap which is frustrating the realisation of the child's right to be heard. Lack of consistency between courts. A key finding in our childcare proceedings in the District Court study, feedback from frontline practitioners during children's rights and child protection training in a 5-country EU project that we ran, and a dominant theme in our current data collection and the voluntary care in Ireland study is professional frustration and concern regarding a lack of consistency between courts about how childcare proceedings should be conducted. This lack of consistency and significant differences between court cultures and practices is problematic for a number of reasons. Firstly, all participants should expect a degree of predictability in our court proceedings. Secondly, citizens participating in court proceedings involving state intervention in family life should not experience significantly different models of practice depending on their address. Thirdly, there is some concern that in courts where an adversarial approach is dominant, that a focus on the welfare of the child can be lost, that this model is not conducive to facilitating children's participation. It can lead to significant delay in decision-making and significant extra court time for professionals. Clearly, this issue is inextricably linked to other reform items, including a lack of specialist family courts and judges, limited judicial and interdisciplinary professional training, the absence of a judicial council, the need for investment to address judges' high caseloads, and suitable child and family-friendly court facilities. And finally, articulating a clear model for childcare proceedings. There is a pressing need for the Oireachtas, through the Childcare Act 1991 reform process and through the establishment of specialist family courts, to articulate a clear vision of what the orientation of these proceedings ought to be. The revised Act should be detailed in describing the model to reduce implementation discretion and to promote consistency. Lessons from other jurisdictions illustrate that there is no one ideal model that can be adopted ready-made from the shelf. Indeed, caution will need to be exercised to try and avoid unintended consequences, such as those discovered with time limits for child protection proceedings when introduced in England and Wales. However, there is clear evidence in other countries of significant reforms of the court and court-like decision-making models for child welfare removals. When comparing Ireland's childcare proceedings with the reforms in other countries, the Irish system appears dated and has changed little despite wider changes to the child protection system and legal and constitutional developments. Difficult decisions will need to be made. Significant investment is required, and changes may be hard, but the research and practice level evidence now available is clear that reform is required. Whatever model is proposed, it should attend to these questions. Is the new model child and parent friendly, maximising participation and amplifying the proceedings focused on the welfare of the child? Are decision makers sufficiently trained and resourced to make timely and evidence-informed decisions in the best interests of children? What principles should underpin the revised model, and what practical changes are required to implement them? And what type of implementation strategy is required to ensure that there are no significant deviations in the model across the country? Reform discussions will need to examine whether we include decision makers with specialist knowledge who are not judges, or not only judges, the merits of pre-proceeding processes. What would non-court buildings and rooms look like that are child and parent friendly? Whether time limits on proceedings are necessary to ensure timely decisions. Consistency in the implementation of thresholds for care orders. Protocols for referrals to mediation or similar alternative dispute resolution processes to address impasse. Articulating in detail the principles underpinning the model and codifying these in law. Adopting child-friendly justice principles and practices, exploring how the testing of evidence could be undertaken in lieu of adversarial cross-examination, consideration of a wide range of methods to facilitate direct and indirect participation of children, and the establishment of specialist courts. Based on our research, there is consensus that reform is required in Ireland, but there is less consensus on what type of reforms should be implemented. An independent, focused consultation process such as this and others with stakeholders from civil society, experts by experience, social work, law, professional associations, the court service and relevant state agencies could go some way to informing the decisions required about these reforms. What is clear is that children and parents can't wait another decade before meaningful reforms are decided upon and implemented. Thank you very much.
Burns, thank you very much. Now, before I go into our members in terms of questions and any other contributions, I just want to flag up that at the conclusion of our session today, we'd like to invite our guests to join us for a group picture for our report. I forgot to flag it up last week, and members all just scattered to the four winds. So there was only a couple of us left. So if you're happy to do that at the end of the event, we'd be grateful to you. So without any further ado, the first to indicate to me was Deputy Jack Chambers, followed by Deputy Jim O'Callaghan, Deputy Clare Daly. Any other member wishes to? Donnchadh? Okay. Jack, you have the floor.
Thanks, Chair. I'd like to thank all the guests for very comprehensive submissions. I signalled first, Chair, because there's health questions on at 10:30, so I have to excuse myself early, and apologies for that. So I won't be here for the group photo. I just wanted to ask, I suppose, explore a little bit the in-camera rule from Dr. Burns. It's something I raised with some of the other guests and tried to ascertain their ideas about how we can reform it and how we can update it. Obviously, you mentioned in your submission the problem with it at the moment and the issue of contempt. Do you have any, I suppose, reform proposal around that specifically that you'd like to indicate to the committee, or something, a model that you'd like to see updated in that, from that perspective?
Sure. I suppose the two reforms of the in-camera rule that have happened so far have been somewhat successful. You've already heard from Carol Coulter and all of the work and the transparency that is brought to the court process. So I think any fear that we might have that very controlled experienced professionals reporting on the process can be beneficial for us to help make decisions. My issue is that I think if we're going to make decisions, it's unfair to make decisions without hearing directly from the people who the decisions affect most directly. I think the time is long past where we don't trust children and young people to speak for themselves, and that we need other people to speak on their behalf. And in particular, I'm sure parents have many things to say, as we've heard from the men's group today. So I think the reforms need to be clear, that a number of methods are appropriate, including researchers and others directly being permitted outside of proceedings. Various bona fide organisations, as clearly mentioned in the other amendments, and that they are directly permitted to speak to children, young people and parents, and do that in a responsible manner. And fora like this and others can then hear directly from those involved, and that can inform wider decisions. We have some good evidence now about how childcare proceedings are working, but it's not deep enough. And we should be really encouraged by the success of the current amendments.
Thanks. And Dr. Shannon, you mentioned in your submission around the issue around children not being heard, and that despite the Children and Family Relations Act 2015, you've said that it is not yet clear how it's being properly implemented or fully implemented. Can you give a picture of how there's a mismatch across the system, and I suppose it's applying? It's at the discretion of certain judges, and you've got a whole inconsistency there? And what's the impact on children in that scenario? Maybe perhaps Flack and the others want to come in on that as well. And what legal remedy is there for the system failing to match the present legislative provisions?
Thanks very much, Deputy, for the question. I think it's a fundamental question. The Irish people voted for a system whereby children would be heard, and the expectation is the Oireachtas would move to legislate in a coherent fashion for hearing the voice of the child. I've had quite a lot of experience internationally on this issue. I have regularly been asked by the Anglophone, Germanophone judicial network to speak at conferences as to how systems operate internationally. We now have a constitutional principle that children should be heard, but what we haven't is the infrastructure. And I would argue that we have world-class legislation, but third world infrastructure when it comes to implementing a lot of the reforms. Where it's lacking is in the detail. I suppose what we need to do is we need a system where we tailor the proceedings to the needs of the child, and that's sometimes something we lose sight of, because it is my view that what we need to be clear about is that there are various methods by which we hear the voice of the child, and what we need to look at is we need to look at where the child's at. And if we look at the guardian ad litem system, we know that the guardian ad litem provision is inconsistently implemented. When it comes to judiciary hearing children directly, what we need is a structure around that. And we have a decision which I cite in my opening statement, decision of Judge Abbott of the High Court, which provides some guidelines. But what we need is a clear framework for hearing the voice of the child, so that we have consistency. So no matter where a child lives, that child has the opportunity to have his or her views fully heard. So how can that be achieved? Well, it can be achieved by having, in my opinion, a piece of legislation where we map out the various methods by which the voice of the child is heard, and that the guardian ad litem system, hearing directly from children, or whether it is a judge that hears a child, or whether in fact the child is heard through an expert. And that should revolve around the needs of the child rather than the needs of the system.
Thank you, Geoffrey Shannon. Would Eilis or Stephanie like to add to that? The Deputy asked Flack just if you have something,
just to agree with Geoffrey, we have, as he says, world-class legislation, but it only can be enforced if it's resourced, and resources are a really fundamental issue, and structure is a really fundamental issue.
Okay. Would you like to add to that, David, please? And then Kenneth, and then I'll come back to the Deputy. Please.
Yeah, because, I would like to spend some time, it's weakness, but I haven't, looking at the weakness in the current system, but I haven't got the time to do that. But I would like to say very clearly that the impact on the legislation as it currently is, 4 years minimum, has huge impact on children, because not only is that 4 years a minimum separation time, it tends to include huge amounts of litigation between both parties. It can be very vitriolic. Parents then look at their children, who they're siding with, and the outcome for children is very, very bad. We look at some of the other models. I used to formerly work with the European Commission, and I have close friends. I'm not an expert in the legal side, but I've seen what they do in some of the Nordic countries, as an example. They have no-fault divorce systems. They have mediation in force. They can separate after 6 months and divorce after 6 months if both parents are consenting. That has a huge benefit to children. Can you imagine the outcome where differing divorced parents actually cooperate with each other? I'm not saying they're going to be the best of friends afterwards, but they actually cooperate together with the upbringing of their children. And they will then work out the finances and the maintenance and things through a mediation process. If that is motivated, then the numbers of people here who do not have to go through the 4 to 5 years minimum of litigation, and it is really vitriolic, and I have to say straight out, the only winners are the barristers and solicitors. None of the children benefit from this. These models that they use in the Nordic countries are to be looked at. If there's going to be reform, you have to ring fence the monies in the families. Lots of these families lose huge amounts of money. They are torn apart. Their assets are stripped. The whole issue is the custody and asset stripping battle. What's worse, and it's already mentioned, is some of the judgments. There's inconsistency in a lot of the judgments, and I can't understand this. If there is legal requirements to do and to deliver for the welfare of the children, why do barristers play to judges? They know they might get a better result with one judge and the other. They all know these games internally. I've witnessed it myself. So I would strongly recommend that the models that are used in some of the Scandinavian countries, where mediation can lead to non-vitriolic, non-adversarial results, protects the children. The children's rights are never looked at in these cases, and I'm not going to go into any more detail, but I've witnessed it.
Thank you, David. Kenneth, please.
To Professor Shannon's contribution on the Deputy's follow-up question, while enabling legislation to clearly indicate what direct and indirect kind of methods from hearing from children will be, it's essential. But you also need to look at the court infrastructure. The contribution from FLAC outlined the Dolphin House. If you'd like to go and look at the old Bridewell on Chancery Street, and so these are the most sensitive proceedings that are possible in the courts. You have very dated buildings surrounded by razor wire. It's not really conducive to hearing from children. So you can have legislation, but we need to invest in the physical infrastructure.
Thank you. Back to you, Deputy Chambers. Are you okay? Thank you very much indeed. And we go on to Deputy Jim O'Callaghan, please.
Thanks very much, Chairman, and thanks very much, everyone, for coming in this morning. It's been very useful for us. We're preparing a report, so obviously we're hearing from a wide variety of people, and we'll consider all the submissions and come up with recommendations at the end. And David, can I just start with you in terms of men's voices? I'm sorry, talking about men's voices, my voice is vanishing, so just apologies for that. But you're obviously correct. Family law cases are very adversarial. They're very acrimonious. But I suppose people opt to go to court. Either a woman or a man make the decision to go to court. So it's not just though it's mandatorily imposed upon them. But in terms of what you're suggesting about a mandatory mediation, I'm trying to think, how would that operate? Do you think that people would have the right to go to court taken off them, or would there be some process whereby once they initiated family law proceedings, they would have to get involved in a mediation process? And what would happen if that mediation didn't succeed?
Is it which David?
David, Frank, or David?
My lights on.
It's between the three of you. Make a call.
Yeah. Sorry, yeah. Okay, well, I mean, we think that at the moment access to the courts, access to court should be the last resort. At the moment, it's far too easy, and too many people just want their day in court, and they get in there a little bit too easily. We think there should be some hurdle or some attempt made, and we believe that, yes, mediation should be mandatory before going to the court.
Okay, like we introduced legislation last year, it's called the Mediation Act, and it requires lawyers to advise clients about the option of mediation before they institute proceedings. And obviously, certain family law proceedings are excluded from that. But it still doesn't oblige people to go to mediation. They just have to be advised about it. So what happens if you're a husband or you're a wife and you don't want to go to mediation? You want to go to court?
Well, for a start, I think if somebody refuses to go to mediation, I think for a start they should be denied legal aid. That is one way of dealing with it. But certainly, I think it could be made a mandatory condition of coming to court, because we have made a suggestion that before someone gets into court, what we could have is a requirement that they have a document signed by both parties and by a mediator stating that they entered into meaningful negotiations at mediation. This model works in labour disputes. You cannot get into labour court unless you've gone through what used to be called the conciliation service. You must first be seen to go through that service. Otherwise, you don't have access. So we think really we need to restrict access to the courts.
Okay.
Dr. Shannon indicated he would like to, and perhaps Eilis as well. Yeah, just please take up the opportunity.
An alternative approach maybe to look at mandatory information sessions, because I think there is a key issue of access to the system, and I think that there would be profound constitutional difficulties with attempting to introduce mandatory mediation. I do absolutely understand the purpose. I think what you're suggesting I passionately support, but I think if you have two parties who are involved in litigation and you bring home to them the reality of a set of court proceedings, and that the real victim in those proceedings may very well be the child, I think it will have a very sobering effect on the family. And I suppose what you're attempting to do is to ensure that you blend in that objective with what's really constitutionally possible. And there are models which I have advanced. I prepared a lengthy report last year in my capacity as Rapporteur on Child Protection, in my 2018 report, where I canvassed the issue of mandatory information sessions. I do reference it also in my opening statement, but I think it's an issue perhaps that's worth looking at. And in terms of mandatory mediation, it would be interesting to look at the approach adopted in Florida, where this issue had been introduced, and maybe the success of that system might be worth considering if the committee is minded to look at this issue.
Eilis, thank you.
Eilis, please.
I mean, we would encourage that mediation would be heavily resourced and that people would be encouraged to do it. But the essence of mediation is that people are coming together bona fide, trying to make an attempt to resolve an issue, and that there's an agreement to try and resolve it. But the reality is that some cases simply aren't suitable for mediation, and there may be a very unequal level of power between the parties, and there may be allegations of assault or abuse, and people may need speedy access to the courts for protection. So I think the notion of mandatory mediation is just an anathema to the concept of your right to access the courts to be able to protect yourself and your children.
Okay. Stephanie, do you want to come in?
Responses? Oh, sorry, I beg your pardon, Stephanie. And then we have David Ella going to come in as well. Please.
Yeah, just to add briefly to Eilis's comments, mediation is considered, it's considered best when it's voluntary, and, to repeat, mediation isn't suitable for every particular case that might present, and there's an implicit acknowledgement of that within the Mediation Act because it excludes some specific proceedings. Doing something like removing civil legal aid as a penalty for not engaging, and it would be quite a disproportionate response in that case. What might be better to look at would be to make mediation more accessible. There's some research around the provision of mediation services in Canada, where it's available on site in the courts. And people would be encouraged, while they might be waiting to enter an actual court hearing, to maybe engage in mediation processes because they've nothing to lose. They're there already, and the mediation service exists. So that would be something that would be worth looking at if it was a case that the objective was to encourage more people into mediation, as opposed to presenting penalties for not doing it.
Okay. And just before I bring in David, it's just that the questioning deputy is the person we're responding to, and while there may be differences in relation to your respective vision, outlook on these matters, it's not between you both, it's between you and the questioning deputy. David?
Deputy, in answer to your question, I think that the way the Family Law Act, the Law Act of 1995 is structured, does not encourage mediation. It rather creates the expectation that the woman will expect to get the house and will also expect to get the children. And this does not encourage mediation in that situation. And that's why we make the plea for the Family Law Act to be changed. Section 10 in particular of the Family Law Act needs to be changed in order to create a more level playing field in which mediation would be more likely to occur. In relation to the other statements made about the mediation, I understand that in New Zealand, mediation is expected to take place. And there is a poor view taken of people who ignore that and prefer to go to law straight away. Finally, in relation to another issue, another innovation which we have put forward is that the introduction of a Families in Transition program, which operates in some US states, as we understand it. The Families in Transition helps couples to develop skills needed to navigate the whole issue of divorce and separation. And we think that this could play a very positive role in the mediation process, preparing the ground for it, and hastening it and accelerating its success.
Thank you.
Okay, thanks. Geoffrey, can I just ask you in terms of the recommendation that the family courts should be changed so as we have more specialist judges? Like a lot of people have come before us have said that. Do you think we need constitutional change for that, as was suggested by former Minister Shatter, or do you think we don't need any constitutional or legislative change, but in fact we just need to have more specialist judges, but who would still, as you say, be part of the judiciary as they are at present?
I think, Deputy, you've raised a fundamental question, because are we going to be ambitious in terms of the new system we create? If we're going to be ambitious, it may be prudent that we look at any constitutional difficulties that might arise. And the challenge, and I've read the evidence provided by other witnesses before the committee. I'm conscious of the fact we have a children's court that deals with issues where children are in conflict with the law. But this needs to be considered very carefully, and it's dependent on the model of the family court structure that we introduce, and if it's likely to be significantly different from the current system. And I was looking at overnight what had been proposed in 2013, and the intent was that there would have been a referendum either 2014 and 2015. And the initial proposal was that it would be exclusively presided over by a dedicated judiciary specialised and expert in family law. And it depends, Deputy, on the type of system we're going to look at. Is this going to be a system separate to the other areas of the law? Like, I would argue that we have a specialised commercial court system. We have a Rolls-Royce system for commercial law. Yet, when it comes to the family law system, which affects every citizen in this state, we have an impoverished system where we have the most vulnerable members of our society trying to access a system which really doesn't have the capacity to meet their needs. So I would urge ambitious reform in relation to this, and fundamental reform, so that the people most in need of accessing the legal system have the best possible system available to them.
Yeah, and I suppose in terms of the commercial court, those changes occurred without any constitutional or legislative change. There was just change of the rules of court. Also, I suppose, do you think it's appropriate, as in the case of the commercial court, that the family law courts should play some filtering process in terms of deciding what court the case should be heard in, directing it, because at present litigation, particularly family law litigation, is very determined by the lawyers who bring the case. They decide where it goes, they decide the pace of it to a certain extent. Do you think the court should have more of a supervisory and monitoring role in terms of the case?
If we look at a good example of how this operates is in England and Wales, where we have a gatekeeping system. And if I can cite an example, if you have a very difficult childcare case that has the potential to run for 15 to 20 days, and we've seen some of those cases, but Dr. Burns and Dr. Coulter will have sat in on a number of those cases. My view is the more difficult cases should be dealt with at a circuit court level, because if you're looking at what is your vision for the district court, it's a court of local and limited jurisdiction. So that you want to make sure that as many cases can be processed as quickly as possible. And what would happen in another system is that the more complicated and more tractable cases actually are dealt with by a court equivalent to a circuit court. So I would favour a gatekeeping system so that all cases would come in to the system. They would be filtered on the basis of their complexity. I think you would have a much more coherent system, a much more efficient system than you currently have.
Okay. And just to confirm, Dr. Shannon, you think in terms of identifying the voice of the child that we need further legislation that sets out specifically the type of medium through which the voice of the child can be heard?
Yeah, we have a number of different statutes dealing with the voice of the child at the moment. We have the Children and Family Relationships Act introduced. Section 32 of that Act provides for hearing the voice of the child. In the Childcare Act, we have sections 25 and 26 of the Childcare Act. In adoption proceedings, we have section 19 of the Adoption Act of 2010. I think if we consolidated all of those provisions into one statute, that it would make it much more accessible for those looking to how the voice of the child could be heard. And I think it's down to how that is achieved, because it's not just a question of providing for the voice of the child, it's how that is achieved. And I think that the detail of that needs to be provided for in the statute.
Okay. Eilis and Stephanie, thanks very much for coming in as well. And I suppose I wasn't surprised, but I think it's worth noting that the biggest level of queries you get is in the whole area of family law. And I was also disturbed to hear that for people in sort of Blanchardstown and Finglas, they have a waiting time of up to 10 months. So what happens if a woman contacts FLAC and is looking for advice in respect of an urgent family law issue? Can you provide it, or is it?
We don't provide legal representation in family law cases, but in fairness to the Legal Aid Board, they will prioritise urgent cases and they will prioritise cases involving domestic violence. But these waiting lists are there notwithstanding.
And I suppose the biggest theme from your submission, I would have thought, is that you believe the whole area of legal representation needs to be much more resourced by the state.
Absolutely, legal representation and resourcing how the voice of the child is heard, but also resourcing the court system. Professor Shannon referred to the Rolls-Royce system for commercial court cases. We believe the issues that are at stake in family law issues are the most important issues that are addressed in the administration of justice, and there needs to be an equivalent Rolls-Royce service dealing with these issues. We would invite the committee to look at the whole issue of legal aid, perhaps as part of this report, but perhaps as a separate inquiry into it. Anecdotally, we've been told from family law practitioners that up to 80% of people in the district court aren't represented. I think that's a scandal. I don't think that's desirable for the parties involved or for the children or for the early resolution of matters. I think it causes huge delays as the judges are trying to grapple with the unrepresented litigant appearing before them. So there's a real need for the family law court system to be resourced and for the court system itself to be resourced. The court system is predicated on the basis that someone will be represented. The whole forms and procedures are drafted by lawyers with the view that lawyers will be reading them and applying them. And I think there's a real need for the lay litigant to be at the centre of court forms and procedures as well.
And presumably a person coming to FLAC seeking advice in respect to family law issues will know virtually nothing about the processes and procedures involved and the options that are available to the court, so they're at complete loose end when it comes to coming to FLAC. Is that correct?
Absolutely, yeah. And we would argue that there's a real need within the court structure for better information to be available to people. We've seen, if you look at the website in the UK, there's guides available for lay litigants, there's guides available for people as to how to behave when they go into court. I mean, daily we hear from people, and it's not just in relation to family law, but people who are ringing our phone line desperately trying to navigate the court system by themselves. And we would argue that there's a real need for a coordinated attempt to deal with the lay litigant so that people will have access to where they should go, what they should do. Stephanie talked about visiting Dolphin House and her experience of not even knowing what office to attend, not even knowing that there actually is a legal aid board, that they have an office in the building, not knowing where to go, what forms you should fill in, what to ask for. So,
like, is there anywhere where a person such as that can find out information that at the end of the process, you know, the likely court order will be that one parent is going to be given custody, another may be given access, and just the options by which it can be resolved? Is that available?
Well, I mean, there is family law mediation available, but there's no information service available in the area of family law. It really should be the legal aid board. We should have a more kind of holistic version of legal aid. Stephanie was talking about the unbundling of legal aid services. In other jurisdictions, there are places where you can go and you may be representing yourself, but you can go and get advice as to how do I fill in the form, what's actually going to happen in the court. Kind of phrases like call-overs or put it to second call, they're very obvious to people who are appearing in the courts, but they mean nothing to the person who's coming in trying to negotiate the system. So there's a lot that can be done without enormous resources, but things like the court website really needs to be dramatically updated and modernised with guides and visual aids for people who are trying to, before they go near the door of a court, have some access to information about what's going to happen in the courts and what's going to be involved, how long is it likely to take. And the government in the programme for government made a commitment to carrying out an annual review of indicators for access to justice. So we feel there's a real need for solid information to be available to the likes of this committee as to what are the delays in the court system. Is it going to take 3 or 4 years for your family law case to be dealt with? And that there is ongoing, the court services should have easily have access to this information. They should have easily have access to information as to whether someone is legally aided or not. So we need to develop indicators that we can look at. Is mediation available? How long is the court system going to take? What are the minimum number of judges you need to process these cases in a timely and efficient manner? And one of the issues is we don't think there's sufficient judges at the moment here dealing with the family law cases, and there needs to be at least 80 judges.
Okay. Would you like to add anything to what's just been said, Stephanie?
No, I think Eilis has covered.
It's covered it all?
Thanks, Eilis.
Yeah, thank you.
Just finally, Dr. Burns, I don't know, does somebody else want to come in there?
Just a few words there, because I fully agree, but what I'm suggesting in terms of reform is that they may have to cover a lot of areas. Obviously, mediation is important now. That will not suit everybody, but if there can be a reduction in the numbers of people going through litigation and go through mediation instead, that will reduce the pressure on the courts. It may then help the children, because the children can then, a separation could be agreed and a divorce much quicker. Obviously, the divorce legislation has to be, the timeline has to be reduced. But to go through and cut out having to go through that minimum of 4 years, it is hugely beneficial to children. Because the acrimony in the family is dreadful. Now, other areas, if it does have to go to litigation, it should be fair, because basically somebody who can afford extremely expensive barristers versus somebody who can't afford any, you must have the same legal process. Also, I think I've witnessed lay litigants don't have much of a chance. They're entering into an area where they have no experience at all, they have no information, they don't know the procedures, and they just get annihilated. Judges don't, in some cases, don't even give them time for a hearing. So there needs to be proper information. I agree with what's said to date. But it is complicated. There are so many weaknesses. The improvements would be a combination of all of those factors, trying to reduce the numbers going through to litigation in the first place.
Yeah, well, I suppose the ideal solution would be if people could resolve their disputes amicably, but obviously that doesn't happen in those situations, and that's why people feel compelled to go to court. Dr. Burns, can I just ask you about the in-camera rule finally? And I was interested to hear that you believe it's having a chilling effect on research. Like, in practical terms, do you think it's preventing academic research and academic publications in respect of what's happening in the family courts?
Very clearly. So in our childcare proceedings research, which was from 2012 to 2018, we canvassed the views of judges and solicitors. The risk was just too high. It may have been possible. So the in-camera rule doesn't explicitly prohibit, but it also doesn't explicitly allow. And in that type of scenario, we would have required to have made submissions to every single judge that dealt with every single case. It meant that it was unfeasible and it was high risk. Whatever about it being high risk to academics who have some degree of protection in legislation in terms of freedom of speech, it was too high a risk to place children and young people in that position. So it was very clear that we could not proceed.
And do you think we need legislation clarifying the extent of the in-camera rule?
That would be very helpful to everyone. The in-camera rule is there for a good reason. We need to protect parents. We need to protect children. It's important that I suppose it's important that everybody knows the limits of that. But what we're arguing is that the limits are it's opaque. So as Professor Shannon said earlier, in terms of, well, what are the exact methods that are allowed for direct participation for children and young people in proceedings? What we're asking is it needs to be very explicitly laid out with a multiplicity of methods, including qualitative research outside of the proceedings. I think when the amendments were considered, it was about bringing people into the court. That hadn't been thought that actually there are reasons why you need to meet people outside of court and facilitate people in a safe way to speak outside of the court process.
Okay, and another point you referred to in your submission was the lack of consistency between courts. Do you think the in-camera rule contributes to the lack of consistency between courts?
Partly. Judges who we interviewed had said that they were unclear what their colleagues were doing. Now, more reporting from the media would help that. More research would help that. And I was very clear when we talked to participants in our proceedings. We told them about how proceedings were running in other parts of the country, and they were disbelieving. But yet it was very clear that that was just down to the fact that the people who are doing this are very busy. There's not a huge amount of reporting on this. So the more transparency we can bring to the area, the more we can help decision makers, the more we can help participants in the proceedings, and the more we can have a degree of consistency.
And in terms of trying to achieve greater consistency, aside from perhaps the in-camera rule, like, is there a benefit to be gained by guidelines being issued by President of Courts, or how do you achieve greater consistency, do you think? Like, I suppose in terms of the voice of the child, it's apparent that in certain judges assess the voice of the child or attain the voice of the child differently to other judges. Well,
Professor Shannon made it clear that we need a new legislation to pull together. The Childcare Act, at the moment, for example, it's discretionary whether judges hear from children or not. So at that basic level, it's inconsistent with the amendment to Article 42A. I think consistency is clear, and where we need greater consistencies in terms of the model. We have the contribution of Dr. Coulter's research and our research is to clarify that we don't have one childcare proceeding model in this country. We have a continuum of proceedings where some are highly adversarial, some are a bit of a hybrid model, and some are tending towards the more inquisitorial model. We just need to make a decision. And I think we need to, there's an opportunity, and there's a great opportunity in the Childcare 1991 review process that's ongoing at the moment to the Department of Children and Youth Affairs. There was a Supreme Court judgment that once said that childcare proceedings should be an inquiry into the circumstances of the child. That's not really what happens in some areas if they are highly adversarial. I can understand why certain proceedings need to be highly adversarial when facts are contested. But for the majority of cases, we need to have some form of process which has alternative dispute resolutions where communication is clear. One of the concerns of professionals that we interview, particularly among solicitors and social workers, they talk about the damage to relationships between particularly TUSLA and social workers and parents when it gets into very highly adversarial kind of processes. What you have is the social work departments working to support families over a long period of time, building those relationships. If it is that a child needs to be removed or there is a question about a child need to be removed, if that ends in a very adversarial process, those relationships are damaged very quickly because an adversarial process is about testing the evidence and testing the... And I think the evidence from the people we've interviewed so far is that maybe that's not the best way to go. We need to find ways to... What happens is the children get lost in that and it becomes about who wins. And that can't be good. So we need to pause. We need to have at a minimum, we can't have many different systems in one system. We must have one system. And whatever we decide, it must be child and parent friendly. And it must be finding ways to make sure that we can have conversations that keep the child's interests at the centre of it.
Okay, thanks very much. Thanks
Thank you, Deputy Callaghan. And we now move on to Deputy Clare Daly, please.
Thanks, Chair, and thanks very much to everybody for coming in. It's been incredibly useful for us, and I don't want to repeat points made by other deputies today or indeed other days, so my questions might be a little bit eclectic, but bear with me. But just briefly, as Jim finished on the in-camera, we'll pick on Kenneth first on that point. I think you've dealt with a lot of issues on it, and certainly your account of the chilling effect will be akin to my own, and I know, you've obviously said it's impacted on your research. And I found that too, with even people who come to us that were restricted in what we can even say about maybe some horrible experiences that people have had for fear of putting that person in a contempt of court situation, which sounds utterly bizarre. But you've said to Jim there that legislation to clarify would help, and I get that. But is it the case that we need more? I mean, there isn't an interest or the resources there from the media, for example, to keep an eye on family. It's just not attractive enough to sell papers that they would have people in there. Is there not, I suppose, an obligation on the state to provide not just voluntary research projects of people ad hoc going in, but a bit like the childcare reporting situation in public law, that we need some formalised state-sponsored scrutiny? I think Carl Coulter suggested something like that. To me, we'd nearly have to have that to get the openness. Is it something like that? Do you have any information on a pilot scheme that she mentioned about some sort of reporting that was done in the family? I thought there was some done somewhere that I'm not sure on that. Or would it be a case of amending the Judicial Council bills? Or how would we put structure on the change more than just legislation?
The initiative that Carol mentioned, I think she mentioned an initiative in the UK. I think it was, and this is in relation to media organisations rationalising their front of house journalists, and therefore maybe not covering as many proceedings as they heretofore would have done so. If we're interested in transparency, if we're interested in accountability, then an investment of resources. The Department of Children and Youth Affairs have ongoing support for Dr. Coulter's research. I agree, I don't have a magic bullet. I can't point to places in Europe where that's the case, but it would be, we would stand out as a country. The countries that I'm familiar with, we are more secretive than other countries. That is clear. We are more secretive. Other countries have access to court documents, for example. The Kafka system in the UK, for example, researchers would have clear access to that. So therefore, accessing court records, accessing individuals, resourcing projects like Dr. Coulter's over time has led to create, but I think the principle has to be set from the Oireachtas that we're seeking greater transparency, we're seeking greater accountability in the family court system, and that would enable, for example, civil society groups and politicians to gather evidence and then collectively represent some of those issues in a safer way. So therefore parents and children, for example, would be more empowered to speak to these civil society organisations. And I suppose it's about us continuing to support those civil society and grassroots organisations to have a representative role in this regard.
But I think we'd need a combination of those measures really to meaningfully, I suppose, reform the in-camera situation.
I think so. But I think we need to change our culture. I think our culture, maybe in some of the Scandinavian countries, is much more open. We're heading in the right direction, but we just need to keep going, is our key argument. We need all of the things you spoke about. And I think no significant harm has happened so far. I think one of the concerns in relation to the early parts of Dr. Coulter's research was about identifying individuals. But I think the benefits that have accrued have been very significant, and I think we just need to continue with that.
And I mean, obviously resources is part of it, which kind of I'm still stressed and depressed after listening to Stephanie's account of a visit to the courts, but I think it would have resonated with all of us.
Sure.
We kind of felt what somebody would go through being there. And I suppose one of the points that Flack made, and maybe, I don't know, any people have the answers to it, is like we can design, even though it's important to address those issues about the physical structures and the immediate changes we can make. I think you made the point that unless we resource people's access to the courts and obviously all the other points, then the situation is meaningless. So I suppose what I'm intrigued about, does anybody have a kind of a ballpark figure for the types of resources that would be necessary in this? Is probably a bit of an unfair question. I was struck by Stephanie's point that actually if we get this right, the state could end up saving money by doing this properly in the longer term, but obviously in the shorter term it is going to require resources. I mean, in terms of your own situation, you described the deficiencies in the legal aid situation very well, and it pans this subject, but obviously it's not restricted to it. But are there specific cuts that you've experienced, or is it just that the process itself hasn't kept up with an evolving society and you know, changed? Or what's the biggest impediment or figures there?
I'll deal with them. There are specific cuts that were made. For example, the IT services, the budget that was cut dramatically during the recession, and that certainly needs huge investment. But that should be not a major investment. It should be relatively easy to get a proper court website together, and that would be hugely important. In terms of the budget of the Legal Aid Board, it is set at a certain limit, and it obviously needs to be hugely more resourced. But we don't have a kind of, if you paid this much money, you would have a Rolls-Royce legal aid service. But I suppose what we're looking for is a kind of a multiple of solutions, some of which will cost money, some of which might not cost some money. Things like having someone in court who would be available to lay litigants. I wouldn't have thought that's a huge financial resource, but it would make it much more meaningful for people trying to access the courts by themselves.
Yeah, just to add to that, we do know that the figures for the legal aid that the Legal Aid Board are given are in the public domain, and they get about 40 million per annum. And even though there has been increases in the past few years, they haven't really matched the requirements given the number of people who are actually engaged in the legal board services. So we have figures for the number of people that are waiting for legal aid services, but we don't have access to the types. We don't have access to information about the types of cases that they're waiting for assistance on. So I suppose reform in the area of family law, it's kind of connected to this broader issue of a need for large-scale reform in the entirety of the civil legal aid system. So we couldn't really suggest a ballpark figure that we would, recommend to be provided for the Legal Aid Board, in order to deliver the Rolls-Royce service that's needed. What's really needed is kind of a holistic needs analysis of the entire system. So we'd be reluctant to kind of provide a specific figure, lest that become part of the narrative. This magic figure will solve everything.
Okay, thanks for that. I think one of the key aspects of this, as far as I'm concerned, is how if we put the voice of the child centre stage, that can actually be a key plank in reforming our family law situation. I'm just intrigued by some of the points that Geoffrey made in terms of, I know you made the point that the binary nature of family processes is problematic for complex family situations, and that children often want a flexibility in arrangements that the system doesn't allow them to access. So I suppose what I'd like to hear a bit more about is maybe how might that issue be addressed practically? I know you've said we need some legislative change to give the voice of the child more focus, but it's not just guardian ad litem, presumably. I mean, some judges talk to the children, some don't. How practically could we do that? And maybe in that vein as well, you talked about experts in the area of attachment, child development, abuse and so on. And that advice could be provided to judges who are allocated to deal with these. Again, could you maybe expand a little bit on how that might work? Would it be experts sitting down with families, putting together reports, or sitting with judges? How do you see that sort of being developed more practically, I suppose?
Thanks very much for the question. I think it's a fundamental question. I'm very supportive of your vision, because I think if we look at what was said earlier, I do support the comments around the Scandinavian system, because the Scandinavian system builds its infrastructure around children. What happens in this jurisdiction is we build our structures around adults, and we build our structures around available services. So I think that's a fundamental shift. And my view is that what I would urge this committee to focus on is that structural reform, because we have been very progressive in introducing new legislation, but that new legislation will be of very little benefit unless we have actually the proper structures. And what we're missing is we're missing those structures. And in my opening statement, I referenced we think of 1996. This issue was reviewed and was led by former Chief Justice Denham. And in fact, it goes back further than that. It goes back to 1975. So how many generations of children have grown up since we first started debating this issue? And the question that Deputy O'Callaghan referenced was, do we need constitutional change? Like, my view is for modest change, we don't need constitutional change. For ambitious change, prudence may suggest that we do need constitutional change. And coming to your question around hearing the voice of the child, it's a cultural issue as well, in terms of, so it's how we can ensure that everybody agrees that it's important that those most affected by our decisions are consulted on those decisions. And that is my starting point. The next question, how do we do it? And I recall in 2007 being asked by an international judge at the Anglophone Germanophone conference, which was held in Dublin at the time, to say this is very difficult and it is hugely challenging. How I feel we can do it is we can, that's what my vision would be, to have a standalone piece of legislation setting out the nuts and bolts on what you should do when a child appears in front of you. And I suppose I've had some direct experience in hearing directly from children. It's hugely challenging. And what I feel is we need a number of disciplines involved in supporting judges to hear the voice of the child. Because judges don't have specific training. Neither do lawyers have specific training. And that's where, I suppose, when I talked about interdisciplinary work, it is that all disciplines, no one discipline should have an exclusive preserve on this area. And if we're really committed to hearing the voice of the child, what we need to set up protocols as to how we achieve this. And it's going to depend on the situation. It's going to be different in a private family law context. Nonetheless, it's hugely important, because divorce comes as a huge shock for children and usually provokes an emotional crisis akin to a bereavement. How do we ensure that children are heard there is going to be different than in the child abuse context, where, in fact, you have this power imbalance. And that's why it's a complicated project, and it requires a lot of skill in drafting legislation. And I feel if we had an overarching piece of legislation where a number of disciplines sit down and look at, well, how do we ensure that both the voice and the welfare best interests of the child are front and centre in our decision making, and introduce that legislation and then have training for the judiciary. And in fairness to the district court are now undertaking regular training. I've been asked Saturday week to speak at they're having a full day conference on some of these issues. I'm looking at the new domestic violence legislation, how that will be implemented. But historically, our approach here has been that we introduce legislation and it's left there. And what I'm suggesting is that a range of disciplines should come together. We should have this new overarching piece of legislation, and that guidelines should be drafted for hearing the voice of the child. And you will have multiple methods, and we need to equip decision makers to be able to select the best method appropriate to the child in front of you. I hope that's been helpful in terms.
I think it is, and I think from the point of view of our report, I think we would be looking to do or suggest something radical, because the problem here has been, exactly as you say, this has been debated for decades. A lot of very good recommendations made, but no implementation of the recommendations. Now, that's either that people didn't bother about them, they couldn't care less, or it's part of a more, I suppose, deeper cultural problem, which I suppose is the direction I'm heading in now to say, and that if we stood everything on its head and looked at things from a child, it would actually simplify a lot of the other stuff. I mean, in that context, I mean, it feeds in even with the discussions we've had about custody arrangements, 50-50, available only in 1% of, and how much of that is linked to, I suppose, cultural issues. I mean, I think it was David or somebody said, oh, women expect to get the house and women expect to get the kids. So I don't think it is that at all. I think the problem is that we need to address the structural barriers that exist before couples break up, not just after they break up. And the reality is that for a lot of women, their wages are less. They're the ones who are the primary caregivers, or maybe judges perceive them as being the primary caregivers. It's much more normal for women to work lower hours and so on. And unless we address all of those issues, we can't really talk about shared parenting. I think the expressions used by some of the others, like David Pilo last week talked about shared parenting isn't equal parenting, and we need to move things like away from guardianship and custody to parental responsibility, day-to-day contact and all of that. But a lot of the culture or the practical issues must presumably feed into judges' decision-making. If the woman is already the primary caregiver, and that when you're trying to not discommode the children. So we need to think outside that box very much as well, you know. Sorry, yeah.
Yeah, I think you've raised it.
The question is directed to him in the first instance.
You know, I think you've raised a really fundamental question, and at the time of the debate around the Children and Family Relationships Act, I made that very suggestion that we've got to move away from these historic terms, guardianship, custody and access. And at the time, the reason for not progressing along those lines, the suggestion was that it may require more ambitious constitutional change. And when it comes to our family court structures, what I'm saying is that we have now been talking about this since 1975. I think the time is right now for fundamental structural change to ensure that we actually have a system that meets the needs of every citizen in this jurisdiction. And rather than trying to create a system that won't require constitutional change, I would much prefer to see a constitutional proposal put to the people that would allow us to be very ambitious in a new family court structure that we would establish, rather than having a system that we're required to create having regard to constitutional constraints.
Yeah, just, David, I'll bring you in, certainly, but I expect that Deputy Daly was making her way just along the line. That's what she's been doing so far, so I've no doubt there will be questions for you in any event. No, but please, if you'd like to add to what's been said.
Yeah, just a point to make in terms of, and in fact it's almost analogous to the insurance industry, where sometimes you can have outrageous claims and that had to be addressed by the courts to stop. In places like Sweden and Finland, there isn't the pressure to go to litigation because everything is calculated. First, all the support for the kids, that money is ring-fenced, then everything else is split up. If there isn't outrageous claims available through the courts, then people mightn't have the incentive to go to the courts in the first place and may be prepared to mediate. It may encourage and motivate people to go that direction rather than the litigation way. I know personally people from both of those countries who have satisfactory outcomes within 6 to 9 months in that. And it's a model that needs instant looking at, because if you're going to do reform, you want to encourage that. It's not going to be always the case, but there's nothing to be gained by going through the courts. Then people won't necessarily use expensive barristers and solicitors to try and seize assets or demand custody when they don't necessarily deserve it from the other partner.
Okay, back to you.
Yeah, just, I mean, a couple of, I suppose, concluding things. And again, I seem to be picking on Geoffrey. No, I think it's been really useful, and I think it all feeds into everything. But just, I mean, you were saying, and it's also Kenneth, because possible, I'm not sure what, are you contradicting each other or what's going on here? But no, Geoffrey, you were saying that judges have to set firm timetables for cases and so on, and that it should be child focus and, you know, explicitly reference the child's needs and so on, and that should be underpinned by primary legislation and so on. But Kenneth, you were saying that we should have a caution about what happened in England and Wales, an unintended consequence by timetabling. I wonder what happened in England and Wales that we should be avoiding, and you know, what kind of legislative mechanism should we put in place regarding timetabling and case management, because there's no doubt, and everybody would be, the delays are hugely problematic for children and that. So I don't know, is there a difference there? Or?
I think, can I just touch on what Kenneth was referencing, and I think it was the fact that within the UK there was a system whereby a child was placed for adoption within a period of 6 weeks in terms. But what I'm suggesting, and I don't think anybody around this table would be in disagreement, that a child's situation cannot be put on hold while the system deals with his or her circumstances. So I think what we need is that we need a robust case management system so that every case that comes into the system is dealt with within a reasonable period of time. And I very much support, I suppose, Kenneth's view on a process as important as adoption, that it cannot be dealt with in such a tight time scale. But I think generally what we need is we need to ensure that children don't get lost in the system, and that when cases involving families come before the courts, that there is a requirement that these cases are dealt with as expeditiously as possible.
Well, just and add to that, maybe Ken, I mean, what's the best way of doing that? Like, is it a sort of an amendment to family law legislation? Would it be the Judicial Council bill where we put something like that in, or is it resort? How would you do that? Like,
so I think the message that's coming from some of the contributors today is it needs to be, we need to look at this in the whole. So what happened in the England and Wales is they wanted to reduce the average wait from 52 weeks down to 26 weeks maximum. But it was also part of the introduction of a pre-proceedings process, and the pre-proceedings process was to try and take some of the discussions out of the court. What they found was that they managed to reduce in about 60% of the cases to get decisions in a timely fashion, which is what Professor Shannon was talking about. But I think the unintended consequences, the nature of some of the orders that were given were different than what was expected. So the point I raise is that when we make changes, we can learn from other jurisdictions in terms of what they have done, and other jurisdictions have made fairly fundamental changes. So we can learn from those. But secondly, the evidence is starting to come out that no matter what you do, you might unintentionally do something that you didn't expect. And in England and Wales, they did something they didn't intentionally expect. So there was a reduction in the number of care orders, and some of the cases ended up in special guardianship orders, for example, and so on. And that wasn't what was intended. And one of the key messages in terms of timelines, and if timelines are for discussion, and they should be for discussion, obviously the number of judges that are available, as Flack pointed out, needs to be higher. So there's no point in setting deadlines without dealing with the number of judges that are available. But the broader questions about guidelines is that if there are guidelines in terms of the length that a decision needs to be made by X amount of time, that they can't be so rigid that exceptional cases, for example, adoption cases in particular, and other contested cases, are squeezed into an artificial deadline. It's nice to have a benchmark, and it's nice for us to aim for the benchmark, but it shouldn't be an absolute, and I think that's the learning from England and Wales.
Okay,
Just a very brief point that I meant to say to Kenneth earlier. You had mentioned about decision makers with specialist knowledge who are not judges being involved. How would you see that working out? Or
it's happened in a number of countries. So Professor Shannon's mentioned some of the Scandinavian countries, so Switzerland, Finland, Norway. The judge it's a panel of decision makers. So the judge is the chair, mostly. But you would have somebody who would have a social worker, child protection expertise, or a psychologist, or what they would describe as laypersons. So they would be people who maybe are councillors, for example, local councillors or politicians. And therefore there is and I'm not sure how this would work, and I'm not a constitutional lawyer, so I don't know if this is permissible, but what it does is it broadens the responsibility for decisions, because in fairness to judges, these are very difficult, very serious decisions to make, often in isolation from your peers. The question arises, would better decisions happen if we had a broader panel of decision makers? But at a minimum, if it is that a decision needs to be made by a judge, at least the judge has access immediately to experts who are independent and who are available.
An interesting idea. The last question is just on the breach of care orders, because it came up today and last week by Roisin O'Shea, and it's quite shocking that care orders access being ignored and no sanction being applied to that. And I think it was discussed last week. But just in terms of the sanctions, what sanctions do people think should apply? We discussed it last week in terms of the offending parent, if you like, being the victim parent who was denied the access or whatever, getting more access or whatever. What sanctions do people believe? And there was an issue raised last week about the form in the courts that actually, I think Roisin O'Shea had analysed 400 cases of breaches of access or orders, and no penalty or sanction being imposed in any of them, because I think she didn't see any of the application forms being used. Does anybody have anything on that?
Picking on Dr. Shannon. So I'm going to make, the first indicator was David Walsh, but I will come to you absolutely, and if anybody else wishes to take it.
Yes, this breach of access order does take place not only in Ireland, but actually it has taken place in a very wide range in England as well, as was instanced by Judge Paul Coleridge, I believe, did a report on it, and said that it meant that no sanctions were being imposed. It had a very bad effect. The claim, or the sanction that was suggested by Roisin O'Shea seems like a useful one. She suggested that compensatory time be made available for the parent who has been dispossessed, if you like, and that this compensatory period actually should be greater than the period of loss. I think Judge Paul Coleridge actually went farther in England. He suggested something like that. In an extreme case, that the offending parent should simply be denied custody altogether, or be lose custody in extreme cases. But that was
my understanding last week, and I don't know, was that Roisin O'Shea said actually that sanction is there already, but it's not imposed because people don't know if they're breached that they can apply to have a sanction imposed. Maybe I got that wrong, but it does seem, you know.
I'm not aware of the intricacies of the law in that respectively.
Thank you, David. Dr. Shannon, please.
Yeah, that provision is in place. I've written a book on the New Children and Family Relationships Act, and if it's of assistance to the committee, I can make that material available. I deal extensively with the issue of dispute resolution and enforcement orders. Chapter 6 of my book. There is a new section 18D, and that has a number of innovative methods of sanctioning breaches of access orders, including a compensatory time. That is currently provided for in the amendment to the Guardianship of Infants Act that was introduced in the Children and Family Relationships Act of 2015. So the facility is there, so it would be useful just to monitor how those sanctions are being imposed. And I think it's one of the most innovative provisions in the Children and Family Relationships Act, which introduced new provisions into the Guardianship of Infants Act.
Anybody else? Yeah, Eilis, are you
Just
looking?
briefly, I suppose, taking off my flat hat, I used to practice in family law, and I would have represented people who would have come to me and said, look, my child simply won't go on access. And I suppose the concept of then penalising the parent where the child is refusing to go on access seems not necessarily in the best interest of the child, and therefore any sanction has to be based on the best interest of the child. And if the voice of the child was possibly heard properly and if comprehensively, then it may not lead to breaches of these orders happening in the first place. So I just think to kind of turn a family court into somewhere where penal sanctions are being imposed or more access has been given because of breaches of access, I think you might need a more kind of comprehensive response to it than imposing a sanction.
Yeah, well, and I certainly wasn't taking that point in isolation. It was very much in the context of everything else, but it was an issue that was raised previously. It is a provision that is there, that is being ignored, and it's precisely damaging to the children involved as well, like if their voice isn't being heard in it, because equally it could be the other way around as well. The kid who's saying, I want to go, I'm not going, you're not going. And again, it's this by us not having the child centre stage. So look, I think it's been really helpful, all of you, in helping us stand this debate on its head. And I think we've actually progressed matters today, and I've certainly clarified my line of thought on it. So thanks very much to everybody for that.
Deputy Daly, I have to say before introducing the next, I was listening to Dr. Burns, to Kenneth's reply. They did something they did not expect. And referencing who we were talking about at the time, I said, that sounds very familiar. Well, England and Wales, think about it. We've just been watching it all night and in consternation for months on end. Donnchadh.
I suppose a lot of the questions I've asked already, but having said that, there's still huge areas. It's a very, the last two sessions have been very interesting, and these have been very valuable hearings, and I hope it will lead to a very constructive report at the end of it. I'm going to start just with Men's Voices, and just to clarify, there's a statement there from the NEMO forum. Are you, I think one of you mentioned that at the start, are you in a position to answer questions? Are they one and the same? Are you connected, or?
If it is representing.
Whatever the question is.
Okay, yeah, great. I suppose, if I'm reading this correctly, there is a section here in the submission, and it says that the default position should be 50-50. And my understanding is that the default position should be 50-50 custody. Is that the proposition? Is that what 50-50 means?
Well, 50-50 in custody terms, yes, absolutely. 50-50 in terms of asset splits would also be important,
okay. But
that would be after you take away the costs. And that's only a reference to the model that I gave for Sweden, Finland, the Nordic countries. Obviously, you have to take any issues of domestic violence out of the equation. They would be separate issues. But if it's a clean split where there's no other issues than a marital breakdown, then there's no reason why equality doesn't apply.
I suppose, I understand that point, right? And I'm not approaching this from a legal point of view. It's very much a lay point of view, really.
Yeah.
But it does seem to me that it is a difficult circumstance for his child not to have a primary residence. And I'm not sure that would be, I'm sure there are circumstances in which it can work, and it should be something should always be considered. But it does seem to me to be potentially a difficult existence for a child to be 50% of the time living in one place and 50% at the other time, and not to have that primary residence. Would you agree at all, or would you disagree?
Well, we're moving into the 21st century. Everything is becoming very equal. There are circumstances personal, so it's a very hard thing to generalise, but there's no reason why one parent shouldn't be the primary or one shouldn't be the secondary. There's no reason why there's a gender reason why one is one and one is the other. It would be the facts of the particular case that would determine which would be the best parent, and those would have to be taken into account. But if you come at it from a picture of equality, now again, I'm not a legal person myself either. I'm a lay litigant, so I see no reason why equality it's part of our constitution that everybody's equal citizen. Why parents can't be equal as well. There are plenty of cases where it might be more appropriate for the mother to be the primary, but there are just as many cases where it could be the father would be the appropriate primary carer.
Very well. And just in relation, yeah, I just asked another question. If you want to respond to that one as well, I suppose. Like, I mean, in relation to alternative dispute resolution and mediation, like, I mean, I very much see the value of it and say that it can play an enhanced role. We had a discussion last week, though, in relation to whether it's appropriate in instances where there is domestic violence of any form. Would you be of the view that it isn't appropriate in those circumstances? I know you have a very strong view that it should be, generally speaking, mandatory, but, like, I mean, would you make an exception for those circumstances even?
Yeah, because, you know, domestic violence is a criminal act. You know, if one of the parents is behaving in a criminal manner, you know, they don't have the same rights as if a parent is a responsible parent for the kids, irrespective of their gender. I reference again the models in mediation, and I'm not an expert in the Nordic countries. If everything is taken out to ring fence and finance the upbringing and the welfare of the kid or the children, then everything is split 50-50. But if there is an issue, you know, if it's alcohol abuse, drug abuse, domestic violence, that parent will not have the same rights as a parent who is a responsible parent, irrespective of gender.
Do you want to come in there, Mr. McGlynn?
Yeah, just going back to your question about the 50-50, what we're saying is obviously cases vary, their circumstances of every case varies, but we believe that 50-50 should be the starting point. Roisin O'Shea, I think, when she was talking to you, mentioned the fact that there seems to be a kind of a standard formula that's trotted out without taking into account the various circumstances. And it goes something like an overnight every weekend and one midweek overnight. And this seems to be kind of a formula that the judges use without actually taking into account the circumstances. Our view on 50-50 is that 50-50 should be the starting point, and that if anybody wants to deviate from that, they should put forward the case for deviating from 50-50. In other words, taking into account such things as working requirements, availability to look after the children, etc. But starting off, 50-50 should be presumed. Another point was made, I think, by Dr. Shannon about the language around children and the use of this word custody. I'm not aware if there is any constitutional impediment to getting rid of that language, but to me it's inflammatory sort of language. What it implies is that you've got a superior parent and an inferior parent, and I really think we should get rid of the word custody. I mean, the only other time we use the word custody is when we're talking about criminals being brought to prison. So I think we really should change that language.
Okay, brilliant.
David, you want to add something?
Yeah, just to respond to the Deputy, you raised the question of domestic violence. Yes. Certainly there are many cases where domestic violence is clear-cut and where one is clearly doing the violence, committing the violence, and the other is clearly the victim. But as we pointed out in our submission, about 50% of cases it's not clear-cut, and it's not clear who is the victim and who is the perpetrator. Both actually may be both at the same time. And this is the complex area which needs to be looked at. You don't have to, you must satisfy yourself that you are distinguishing which is which, distinguishing whether or not both parents are actually engaged in it at the same time. There is something called a victim-perpetrator matrix, as I understand it, which is used by the Gardaí. And I am afraid that in all cases it kind of assigns one role to one individual and the other role to the other. And we would take issue with that for the reasons that we have set out. The research shows that it's much more complex than that, and it needs to be looked at much more closely.
Okay. Well, I suppose before I move on to the next question, it's not really so much a question, but like I would say that our understanding of domestic violence, it is obviously complex, but it is becoming, I think, legislatively more sophisticated, the response is becoming more sophisticated, but like, I mean, I would say domestic violence on a criminal basis requires proof beyond a reasonable doubt. Where that isn't proven, but potentially somebody is subject to domestic violence, to force them into mediation, I think would potentially be seriously re-traumatising, and, you know, potentially that person might be ultimately successful in proving it and have gone through that. But even if they're not, I think the question still arises. I suppose my own sense is that it's not appropriate, to be honest, but that's just my own view. I just want to ask some of the other panellists as well, because I think, and you can correct me if I'm wrong, but I think you have offered a view on this specific topic, the point of automatic guardianship, and it was also spoken about by Troer last week. So to ask Dr. Shannon, Flack and Dr. Burns if ye have a view on whether, and the Law Society spoke about this and kind of hedged their bets and said, well, maybe that's not fair, but I suppose we're saying that perhaps it's too soon. We want to see what effect the current or the most recent legislative changes around the presumptions and that had. So I just want to see what your own views on a presumption of automatic guardianship would be.
Thank you. Start, please.
When the Children and Family Relationships Act of 2015 was introduced, there was a commitment to review within a period of time the issue of guardianship. This was an issue that was front and centre of the debate at the time of the Children and Family Relationships Act. A commitment was given at the time, in particular in relation to having a register of guardians. It's a hugely important document because it's the gateway to so many other rights, and that was to be reviewed. My view is what we need to do is there needs to be an examination as to how we can ensure that that parents who have a direct involvement in children's lives get the legal rights commensurate with their involvement. So my view is that rights should equal responsibilities, and if that involves, and I think it needs to be scoped out. And what I'm reluctant to do today is to make any definitive statement. I think it's worthy of exploration. I think it should be viewed in two stages. Firstly, having this, I support Troer's recommendation around having a register of guardians. What happens if you agree to be a guardian and you lose that hugely important form? If you had a register of guardians, you could access that. So it's a very substantial right that is the gateway to custody and access. So I would suggest that if this committee were disposed to making a recommendation on guardianship, maybe the starting point might be around the register of guardians, which was hotly debated at the time of the Children and Family Relationships Act, and then scoping out the options available for enhanced guardianship rights. I do feel that there is some legitimacy in the arguments being advanced that we need to look at this issue, to look at the different roles that we all play in raising children. And as I said, if we had a system built around children, is that we wouldn't be getting exercised about guardianship issues. We'd be getting exercised about ensuring that the parent looking after the child has actually the legal rights to ensure that that happens.
Thank you. Moving on to Flack, perhaps.
Yeah, I mean, we don't have a definitive view about it. It's not something we've researched coming here today, but it is a complex issue, and I suppose the overriding criteria has to be the best interests of the child and the welfare of the child.
Thank you. And Kenneth, please.
It's a really interesting question. My contribution to this is of a personal nature, as somebody who had to apply for and get an SI5 to get guardianship for my own child. It was a source of curiosity that the document, first of all, the lawyer had never done one before and didn't know what to do with it. And secondly, there was no register, which meant that I was worried about losing that document. And I can see why there are merits for why a register is really important. But maybe I grew up in a generation where it was socially possible and not culturally reprehensible to have children outside of marriage. And therefore, we have a plurality of family forms now, and we've been very successful as a nation in trying to recognise them. But the point I want to make is that the men that I know who have children who are not married don't know the minutiae of what they are entitled to or not, and particularly don't know about guardianship. And most of them did not know that they were not automatically guardians for their children. and were somewhat worried about the process of how to go about it. So the 2015 Act has made some progress, but the anecdotal on the ground, what I understand, is that there's a lot of confusion about men about what is, how to go about receiving their full guardianship if they are if they are actively involved in day-to-day care of the child, whether they live with the child or not. So some progress on that is required.
Thank you for that, Kenneth. Thank you.
Thank you. My next question there is for Dr. Shannon, and it relates to properly implementing Article 42A of the Constitution and giving effect to the provision on the voice of the child. So I suppose just to, if I'm understanding the situation correctly, at least, I suppose I'm referring back to the discussion we had with Dr. Conor O'Mahony a number of weeks ago, and he identified 3 difficulties, and I hope I do them justice at this moment in time. The first is where an expert is not appointed, and the lack of clarity as to what should happen in those circumstances. The second, that there is not a lot of clarity around determining whether the child has the capacity to have his or her voice heard. And the third is where an expert is to be appointed, but that the parties cannot pay for it. So they were, as I understand it, the 3 difficulties identified. So I wonder, would that accord with your own analysis, Dr. Shannon? And that being the case, like, I mean, is the first of those 3 the primary difficulty? If that is resolved, is that, I suppose, to a large extent, like, I mean, is that the most substantial problem, or are all 3 of equal weight, or are there other issues?
Yeah, I would say all of equal weight. I think it's important that some person should have the standing to ensure that the child's voice and welfare is front and centre when the court comes to make a decision. And that touches on the second issue, which is the issue of capacity. Is it my view that if a child is capable of articulating his or her views, that the best person to articulate those views is actually the child. And sometimes we have a tendency to overly professionalise the system. My own personal experience in hearing children directly has been that children want to be heard by the decision maker. They feel empowered by being heard by the decision maker. And what we need to do then is to provide them with the supports to ensure that that occurs. I do support, and I read the evidence of Dr. O'Mahony, I do support the view that there is a problem with the funding. And my solution to that is I think we should have a national system for the funding of all representatives for children, be they in public or private law proceedings. Because if we look at the Children and Family Relationships Act and we look at section 31 and 32 of that Act, if we look at the funding can very well fall on the shoulders of the applicants. And if the constitutional aspiration is to ensure the voice of the child is heard, there's nothing in the constitutional aspiration that says having regard to the resources of the parent. So I think that it's an access to justice issue, because I think if we are committed to hearing the voice of the child, we should have a national system for ensuring that children are heard in all proceedings affecting them. And the overarching requirement is set out in Article 12 of the Convention on the Rights of the Child, which states that the child should be heard having regard to the age and maturity of the child in all judicial and administrative proceedings. And that's where I feel having a national body such as the Guardian ad Litem Service in the north. And I welcome the developments by the Department of Children. This is currently being scoped out in terms of the childcare amendment bill. But what I'm suggesting is it's equally important in divorce cases. And sometimes we see children as bystanders in the divorce process. Children are hugely affected by divorce, and they need to be supported through that process. So whether it's public or private law proceedings, my view is that it's a question not just of having the expert, but ensuring that the vulnerable parents aren't burdened with the cost of that expert at a very traumatic time in their lives.
Thank you very much. I suppose that a related issue, and I suppose it's one that I would ask to the panel as a whole, maybe, if anyone wants to speak about it. a fair bit has come up in relation to Section 47 reports of the 95 Act, and the point has been made, it's been made to me previously to these hearings, that there is a lack of regulation on the people who can be considered experts under those provisions, and that there is a lack of scope for a party to the proceedings to challenge those reports. So I suppose if any of the speakers have a view on whether there's a need for further regulation or on the scope to challenge those reports.
Kenneth, would you like to?
Yeah,
David?
I would believe, I may come across controversial here, but I believe in many cases these are just spin-off, easy funding for people who aren't necessarily qualified as child psychologists. My understanding is that many of them don't address the key points. They haven't necessarily qualifications and don't look into the family. I'm not saying it's all the case. It's my experience that it's part of a spin-off industry of taking more money from already poverty-stricken families. And if it is necessary to spend 3,000, 5,000, 7,000 euro on getting these specialists in, it needs to be subsidised. It is money out of the pockets of the families who are already in dire circumstances.
Geoffrey, did you indicate, please?
This issue has been addressed in the Children and Family Relationships Act, where, and we see recently issued regulations around the child view expert. What I think is we need similar prescription in relation to Section 47 reports. We need to ensure that those who prepare the reports are properly qualified. We need to set out the terms of reference for engagement. We need to set out a fee scale, because in terms of the cost of these reports can be prohibitive. It is my view that I'm a passionate believer in access to justice. And if you are being charged between 2,000 and 3,000 euros to prepare a report, that automatically excludes a large cohort of the population. And that brings me back to my big picture recommendation. It's having a national, I suppose, national home for all of these reports, whether it's in the public or the private sphere. And that would ensure consistency and a rationale for the appointment of an expert having regard to the case that's before the court or administrative body.
Thank you. Okay, back to you, Deputy.
Just do Flack have a view, or?
We would just agree with what Professor Shannon said. It is an access to justice issue, and we have constitutional provisions in relation to the voice of the child, but if it's not resourced, it's not good. The voice of the child isn't going to be heard.
Just in relation to Flack specifically, I suppose first of all, I'd very much echo the points you've made around civil legal aid, and even though I suppose in a way it hasn't got that much ventilation in some of the previous hearings, because well, in a way it seems so self-evident, there isn't enough money there. It's causing a huge barrier, not only in this area, but generally in a whole lot of civil areas of civil law. So I wholeheartedly agree with that, and I would recommend that be one of our recommendations, is that civil legal aid, particularly where it pertains to this area, be much better funded. I suppose I'm interested in the points in relation to, and I'm not actually terribly familiar with this point of unbundling of legal services, and if I'm understanding correctly, which I may not be, it seems to me that an applicant can go themselves do what might be some of the more simple administrative work, and then that where a complex argument has to be made in the proceedings, that a lawyer might make that, or something like that. So maybe if that can be elaborated upon, but I suppose just to ask the question as well, there is a fair bit in there, and some of it very straightforward stuff, the nutshell guide to the proceedings related, and it's really sensible stuff that I think is well worth taking on board. Just to get the perspective from Flack on this, is this he being pragmatic in saying, well, in advance of a much improved civil legal aid budget, you could do these quick fixes as well, or are they complementary? Like, I mean, is this an interim measure that is absolutely needed and would you rather see actually proper legal representation, well funded, and some of this mightn't be necessary?
Deputy.
Yeah, if I can answer. The unbundling of legal services, there was an initiative in Canada, and there's a lot of research done by Professor Julie McFarlane, and I can, if it's helpful, I can send it to Deputy O'Leary and the other members of the committee afterwards. And unbundling of the legal services it involves providing funding for people that they would access legal aid, but through that they might have representation, or they might have just advice, or they might have assistance with, you know, filling out forms or guidance on how to navigate a court's process, or any or all of those, or a combination. Obviously, from FLAC's perspective, we would like to see, you know, a proper, comprehensively funded civil legal aid set up where people can access advice and representation according to need. In the interim, as I suppose on the way to achieving that kind of larger goal, I mean, we recognise that there's a massive budgetary issue there, and there's a lot of needs analysis to be done in terms of deciding the exact scope of what is actually needed in order to provide the level of funding required. We would like to see these additional mechanisms put in place. They're not, we wouldn't see them as necessarily a replacement for providing people with, you know, both advice and representation, but just this is something that could be examined on the way to getting there. There's a lot of initiatives that could be introduced for lay litigants that don't cost a lot of money, that would make the process a lot more easy to navigate. So does that answer your question?
Yeah, I think so, yeah.
I suppose if I could just add to
Please,
that.
Eilis.
I mean, we've been in existence 50 years, and we've been advocating for comprehensive civil legal aid, so it is a kind of pragmatic solution, but it's not an alternative. We're still advocating for comprehensive legal aid, and again, I would invite this committee to separately look at the issue of legal aid, not just in terms of the family courts, but that it is something that really needs the forensic scrutiny of this committee.
Okay. Just interestingly, access to justice is a separate issue that's on our list of, on our programme of work. And we just pointed that out. Doesn't mean we couldn't stray into it here. Yes, please.
I suppose, like, I mean, I haven't much else said, maybe just for Dr. Burns, I suppose, just in relation to, like, the in-camera proceedings, and it's been touched on previously, like, I mean, it does seem to be that, like, there is a difficulty there that, yes, the area would benefit from greater publicity in the media, but it's just not something the media is going to do realistically in the foreseeable because of cost and the level of labour that's involved and all the rest of that. Like, I mean, is there incentives that you think could be offered? Like, how better can we, I suppose, have these cases reported, obviously within the restrictions that apply in the more mainstream media as opposed to specified projects?
It's not that the mainstream media are not reporting them. Maybe there needs to be more reporting. I'm not sure. I don't have a journalistic background. I'm not sure how you could encourage journalists to cover. In the absence of journalists covering, then court reporting and research is the other part of that. So while Dr. Coulter's research is funded, there are very few other, or research is moderately to small funded. It's largely independent. And you could put some money to the Irish Research Council and it could be a call, and maybe there's other ways that you could go about this. I think Carol Coulter has been very effective in terms of using the media to tell the story of the proceedings. It would be duplication maybe to go at it at that level. We need to find ways to help the story be told in different ways. So if Carol Coulter is a reporting project, then people like us are researchers, and then if the civil society sector felt that they were more able to comment on the proceedings without risk of being held in contempt, that might help a greater understanding of it. But you would need to ask journalists about what might give them incentives. I mean, these are, when they are reported, they're reported fairly prominently when they are reported. And there is a public interest to understand how these proceedings happen, what it's like for the participants to be in these proceedings, and also to learn about and we've learned today about what the conversation about developing specialist family law courts is only one part of a broader suite of changes that needs to happen in society. And Deputy Daly referred to some of those earlier structural issues in terms of poverty and family support and prevention and having an adequately funded TUSLA and support for legal aid and developing their budget. So focusing on the in-camera rule and liberalising the in-camera rule will help tell more of that story also. It's not just about what happens in the room, it's about what happens to families that mean that they end up in that court in the first place. And I think that's very significant because there are issues of housing, issues of poverty and so on that we need to kind of deal with and deal with kind of comprehensively.
Okay.
Thanks very much.
All right, Deputy. Well, I have to say it has been a very informative engagement, and I want to thank each of you sincerely, not only for your contributions in the course of the Q&A with our members, but also for the written submissions, some that are quite substantive that we have received in advance. And all of this is our third and our intended final engagement in relation to this subject. So on behalf of the Justice and Equality Committee, I want to thank Men's Voices Ireland, David and Frank. And David, Ella, I'm not quite sure of the relationship between NEMO Forum and Men's Voices Ireland, but so be it. You've come together in any event, so you're all very welcome. Dr. Geoffrey Shannon, who has been with us on many occasions, and great to have you back. Geoffrey, thank you. From FLAC, Eilis and Stephanie, both not strangers to this institution either, I may add. And Kenneth, it's great that we have somebody from UCC who isn't in some way partly responsible for Deputy Donnchadh being here, because this has happened before, but your hands are absolutely clean of all of that. Well done, well done. So without any further ado, our great thanks to you all, and the Joint Committee is adjourned. I was teasing them earlier, we'll be back next week, but of course we won't. It's the Patrick's week, so there is no sitting next week. We're adjourned until 9 a.m. on Wednesday, the 27th of March.